Today is August 12, 2013. I am here with Rich Saphire at the University of Dayton School of Law in Dayton, Ohio. Since the late 1970s, Rich has served as a board member and a volunteer attorney for the ACLU of Ohio. He acted as the board's vice president from 1980 to 1981, and again from 1983 to 1986. In 2013, he was elected general counsel and is currently serving in that position. Your interviewer today is Emily Wicks, history associate for the ACLU of Ohio. Rich, thank you for being here with me today.
Glad to be with you.
So let's start out with some background questions. Can you tell me where and when you were born?
I was born in Cleveland, Ohio, November 27th, 1945. At the time that I was born, my family lived on Huff Avenue, just off of University Circle. And when I was about 6 months old, my family, I have an older brother and an older sister, my family moved to Shaker Heights. My dad was a blue-collar factory worker, and my mom was alternated between being a home worker and doing secretarial work.
So where did you attend college and what was your major?
I went to Ohio State University, and I majored in what was then called social science, which was a combination of political science and sociology and history.
And how did you decide to attend law school, and where did you attend?
Well, that's a complicated question. Actually, the answer is complicated. The question is straightforward. I attended law school at Ohio State University, my first year of law school. My brother Dave and I went to law school together. He's a year and a half older than me, but we started law school at Ohio State together. I completed my first year of law school at Ohio State and then decided to leave Ohio State. I was in good standing. And I moved to Cincinnati, where I went to work as an adult parole authority for the state of Ohio. And I spent about 4.5 or 5 years working as a parole officer. After being out of law school for about, I don't remember, 6 months, it might have been a year, I went back to law school at what was then called Chase Law School in Cincinnati as a part-time student, went to night school, and graduated 3.5 years later.
And after graduating law school, you became an attorney for the Legal Aid Society of Cincinnati. Can you briefly describe your experiences and responsibilities there and how they influenced your future work with ACLU?
Sure. The only job I was really interested in when I was in law school was a legal aid job. And I was fortunate enough to be offered a position with the Legal Aid Society of Cincinnati. The first 6 or 8 months, I worked at the headquarters building for the Legal Aid Society and just did the whole variety of work that legal aid lawyers did back then and assume do now. Housing work and creditors' rights work and paternity cases and just a whole range of issues that affect low-income clients, low-income people. And after about 6 or 8 months, I was asked to become the chief attorney of a neighborhood law office in a part of the community of Cincinnati called Avondale. And I and one other attorney, a gentleman by the name of Les Gaines, for about 2 years or so, staffed that office and handled all kinds of cases. When I walked into that office, I had just been out of law school for about 8 months, and I inherited an active caseload of about 200 cases. And so I had to learn and practice law by what we referred to then as the fire and fall back philosophy. But we did the whole range of issues that affect low-income folks. In some quarters of the legal community, I became known as the bastard lawyer, or probably some people call me worse than that. And that was because I had a very heavy caseload in paternity cases representing defendants who were being sued for paternity. I did that for a year and a half or two, and then I became much more involved in landlord-tenant work and worked with a group of lawyers to develop and get funding for a landlord, we called the Landlord-Tenant Project, which had an office in downtown Cincinnati. And for the last 2.5 years or so of my practice, I was chief attorney of the Landlord-Tenant Office. We had a staff of 3 lawyers, as I recall, and I think 2 support people. And most of what we did was defend against evictions, and we did a lot of community organizing, tenant organizing, a lot of tenant education work. Spent a lot of time in low-income housing projects, organizing tenant groups, and dealing with a wide range of issues that affect low-income housing. And about that time, this was a little after 5 years or so of my tenure at Legal Aid, I decided for a variety of reasons that I wanted a change, and I applied for and was accepted at Harvard Law School and went back to law school to get a Master's of Law degree.
So have you always been interested in civil liberties and equality?
Well, always is an ambiguous word. Since I can remember, I was interested in issues of equality and civil liberties issues. When I went to college at Ohio State, it was really quite a period of time for social activism and social turmoil. It was in the middle of the Vietnam War, beginning of the women's rights movement, environmental movement just beginning. There were a whole range of social movements, including the civil rights movement, that sort of got steam during that period of time. And so, I became involved in not in leadership in civil liberties or political groups on campus, but I went to a lot of rallies and was interested in all of those issues. I think that interest in part was what sort of motivated me to want to go to law school.
So how did you first get involved with the ACLU of Ohio?
That's a good question. I've been involved in the ACLU for so many years that I actually can't remember the moment where I said, "Aha, that might be a good idea." I think I certainly heard of the ACLU. I wasn't active with the ACLU as a student. I don't even recall there being much of an ACLU presence at Ohio State at the time that I went there. But I think that the work that I did as a legal aid lawyer, as a poverty lawyer, much of it was civil liberties oriented or related to civil liberties issues. And I think that those experiences sort of further whetted my appetite to become involved in the law in a way that might affect what I consider to be positive social change. And when I finished my master's work at Harvard, I went out to Oklahoma City to teach for a year at Oklahoma City University School of Law. And I was out there for about a year, and I got an opportunity to come back to Ohio at the University of Dayton, which was just beginning a law school that had existed 25 years earlier, but was now coming back. And I think probably I was teaching here at the University of Dayton for a couple of years, and I just met some folks who were civil libertarians and got interested in it and got involved as just kind of a regular card-carrying member of the ACLU. And that involvement continued over, as you said earlier, about 4 decades.
So can you explain what roles you played at the ACLU of Ohio and when you held these positions?
That's also a straightforward question that probably invites a complicated answer. When I became involved really actively involved in the ACLU, not just a member of the ACLU, the ACLU had a pretty highly developed system of chapters around the state. I don't think there are any chapters anymore, but much of the work of the ACLU was organized not around a state office, but through chapters. And chapters would have meetings, chapters would elect representatives who would become board members and go to Cleveland at the time for board meetings. And this is probably probably the late 70s or so, I don't know, 77, 78, 79, somewhere along that period. I became active in the Dayton chapter. And the Dayton chapter, I don't remember, that we probably had 75 to 100 people who were really active. And we had meetings where we'd have 35 or 40 people would come to meetings, and we had a board of directors and all the rest. Over a period of time, I became kind of a self-appointed legal director of the chapter, and sort of handled much of the legal work that took place in Dayton, and responded to lots of civil liberties requests from both media and from people in the community. And this kind of lasted well into the 80s, I'm guessing until the late 1980s, when for a variety of reasons, some of the older people that had been actively involved in the chapter moved, or some of them died, and whatever. And so over a period of maybe 4 or 5 or 6 years, the chapter, as was true of a lot of chapters around the state, became increasingly less active, and much more of the attention of the ACLU focused on what was going on at the state level as opposed to the local level. So I can recall, for example, as a faculty member of the law school, having courses where I would have students who would intern with me or would take courses for credit for the ACLU. We had, for a period of time, we had an office. Actually, there were probably a couple of places where we had an office. We actually had an office, and we had a part-time secretary. As a matter of fact, we got involved in a piece of litigation surrounding one of the places where we had an office, as I recall. And I'd have students who would staff a telephone. Basically, we had an office, we had a telephone, we had a person who would come in a few hours a week to do secretarial work. But we'd have a phone listing, local phone book, and we'd otherwise advertise by word of mouth, and people who were interested in contacting the ACLU would call that number, and I'd have students who would return their calls and then make a report to me, and we'd discuss those matters. And eventually, much of all the intake that takes place now, I'm guessing it takes place for the ACLU, takes place in Cleveland, but at this time the intake was taking place at the chapter level. And so there are hundreds and hundreds and hundreds of cases over the year. Most of them didn't become cases, but people, potential clients, who contacted the Dayton chapter, and I eventually made decisions with respect to whether we would pursue those matters or not pursue those matters. There was another part to your question that just eluded me. Oh yes, and I became more active in the state chapter, and as your introductory bio suggested, I did, I think, 2 short stints as vice president of the board. I sort of went off the board for a couple or 3 years. Back in the mid-1980s, I went out to California to teach for a full academic year, and I wasn't involved in the state affiliate then. And I came back, and I think probably took a year and a half or so before I became re-engaged with the ACLU. So there was a period of at least a couple of years where I wasn't on the board, but ever since then, and I went back to California 10 years later to teach again, and I went off the board for a period of time, but then when I came back to Dayton, I got back on the board. So more or less, with a couple or 3 years off for good behavior, I've been on the board for, I don't know, 40 years. And
you were recently elected general counsel. Can you talk about your responsibilities in that position?
Well, I'm just sort of beginning to feel my way into this job. The general counsel has overall responsibility for the direction of the legal program of the ACLU, but it's not like I don't consider myself to be a general counsel in the sense that a corporation would have a general counsel or a government agency would have a general counsel. It's very collaborative. I work very closely with James Hardiman and with the rest of the legal staff in Cleveland when issues come up and we're asked to get involved in cases or to take a case. We have telephone conversations, we discuss the case and the issue, and usually we all come to a consensus about whether we should pursue the matter and what position we should take on the matter and so forth. There have been a lot of really interesting cases that we've been involved in over the last 6 months or so, which is as long as I've been general counsel. interesting First Amendment issues involving church-state questions and freedom of expression questions and so forth. And so far it's just a kind of a collaborative arrangement. If James wants to recommend to the board that the board take a case, I think our bylaws require that I agree to that. And thus far, we haven't had any issues at all. We work very harmoniously with each other. I have instituted a practice where every 3 or 4 weeks I have a conference call with James and the rest of the legal staff and Jack Gutenberg, who's our current president, simply to talk about the docket, kind of get an idea of where things are at, just so that there are no surprises. So pretty much it's kind of on an as-needed basis. I don't go nosing around into what people are doing. When people are interested in my opinion, they call me and I offer my opinion.
You talked about your experiences in Dayton a little bit. I'm wondering, can you mention some of the people that you worked with who were active in the Dayton area?
Oh gosh. This is going back.
Yeah.
This is going back 25 years or so. I remember some individuals, yes. I remember a woman by the name of Betty Ruth Fannin, it's Fannin, who was a real dynamo of a woman. I was in my 30s, I guess, early 40s at this time, and Betty Ruth was in her 60s, I think. But Betty Ruth was just a real institution in this community, a civil liberties institution in this community. And she wanted to solve all the world's civil liberties problems, and she was actively involved, a very vocal and constructive voice in the community. She died, I want to say about 6 or 7 or 8 years ago, and I think the board issued a resolution in her memory. I remember one woman named Charlotte Clark, who was about the same age as Betty Ruth, and Charlotte was sort of like the organizational person for the local chapter, where she handled a lot of the administrative stuff, but was very thoughtful, very knowledgeable about civil liberties issues. I can see some faces. Charlotte also died not too many years ago. I can see some of the faces, but those are the two names that sort of stick out. But as I said, we had a board of directors where we would meet, if not every month, we certainly met every other month. We might have met every month, and sometimes more frequently. And we would have, for a while we were meeting at a Miami Valley Unitarian Fellowship, which is not far from the university here. And we would always have 15 or 18 people at board meetings. And a lot of engagement, a lot of people who are really committed.
You had mentioned a case dealing with where the ACLU chapter met. Could you mention that case name and what it was about? Yes,
the Miami Valley Unitarian Fellowship against the city of Oakwood. Oakwood, Ohio is it's a city that's just adjacent to Dayton. In fact, you could walk 5 miles west from where we are now and you'd be in Oakwood. It's a very sort of exclusive, very wealthy, fairly homogeneous community. And in Oakwood was this Miami Valley Unitarian Fellowship, and I don't know if you know much about Unitarians, but Unitarians, in my experience, and I'm probably getting this completely wrong, but in my experience are folks who are religious much more in the spiritual sense than a theological sense, people who are really committed to social activism, to social action. They had a place of worship and community center, as it were, up on Far Hills Avenue, about maybe a mile and a half from where we are now. And they invited us, I think this is because either Charlotte or Betty Ruth were members of the fellowship. They invited us to use an office that they had in their basement that wasn't being used, which is where we had a desk, we had a chair, and we had this telephone message unit that I referred to, where the students would go 2 or 3 times a week to clear phone calls and get back to people and so forth. The fellowship decided that it wanted to, as I recall, that it wanted to expand its facility to include a daycare center. They had some property somewhere on its some area somewhere on its property where they wanted to build a little extension to the building that was already there. And so they applied to the Oakwood Zoning Commission for permission to go ahead and do that. And the Oakwood Zoning Commission refused to provide permission. And as I recall, the original justification was that they would create traffic problems and this problem and that problem. It made it sound like it would be Grand Central Station. You'd have people coming in all the time and it would tie up traffic for miles and miles and miles, which of course was absolutely ridiculous. And so we tried to work things out amicably with them at first unsuccessfully, and so I filed a lawsuit in Common Pleas Court here, challenging their refusal to grant this zoning variance, both on state law grounds and also freedom of religion grounds. And one thing led to another, and eventually they backed down, and we settled the case, and they allowed the fellowship to build its extension.
Was the city against ACLU using that building? It seems like in the dockets they were mentioning.
That issue came up a couple of times during, as I recall, once again, a long time ago, but as I recall, that issue came up a couple of times, and I'm sure there were plenty of people in the Oakwood government who were not exactly thrilled with having the ACLU have an office presence. As a matter of fact, the issue came up, I think an issue came up where they claimed that the ACLU being in the building constituted a business presence, and that the area was not properly zoned for business. So that was an issue as well, and but we ended up, as a settling the matter, we ended up they got their daycare center and we stayed in the building for a period of time.
So looking at the ACLU of Ohio over time, how has the organization changed during the years you've been involved? What are the major differences between it today versus the 1980s?
Well, first of all, it's a much more viable organization today than it was in the 80s. When I first became involved, I think this is true. I'm trying to remember if there was somebody as executive director before Benson Woolman. Either when I first became involved or shortly after, a gentleman by the name of Benson Woolman became executive director of the ACLU. And Benson was a real institution. No other way to describe him. He was brilliant and he was erudite, and among other things, he was a restaurant critic for the Columbus newspapers and, excuse me, for the Cleveland Plain Dealer. No, the Columbus newspapers. He lived in Columbus, not Cleveland. And Benson knew more about civil liberties and more about constitutional law than most constitutional lawyers know. And as a matter of fact, sometime after he stepped down as executive director of the ACLU, he went to law school and became a very successful and accomplished lawyer in Columbus. He had a practice that focused largely on employment discrimination and civil rights and issues like that. Benson was wonderful at representing the ACLU, very articulate, had a very sort of grand view of civil liberties, ran wonderful board meetings where we had very, very sometimes highbrow discussions, abstract, conceptual, theoretical discussions of civil liberties. It was a great time to be a member of the ACLU and be on the board, because you go to board meetings and you'd spend 2 or 3 hours debating important civil liberties issues. The problem is that there wasn't much being done on the business side of the ledger. And what was being done, rumors have it, you'd have to check this with Chris Link, our current executive director, but rumors had it that Benson ended up subsidizing or supporting much of the work of the ACLU out of his own bank account. But it was a time, I don't want to call it the heyday of civil liberties, that's an exaggeration, but it was a time when you would go to board meetings and there were probably a dozen law professors on the board, which is not always a good thing, but and lots of other lawyers on the board, and you just end up in these really sophisticated, really interesting issues about what position we ought to take in a particular case. And there were, in a room, if you have 15 civil libertarians in a room, you usually have 27 opinions about a matter. And so we'd have these really great, wonderful discussions and debates. But as I said, the organization wasn't very viable financially, and so it was much less active and much less engaged than it might have been had more attention been paid to the business side. When Benson left, he was succeeded, and I'm trying to remember her name. I should remember it, but I don't. He was succeeded by Chris's immediate predecessor. She really had to do triage on the organization to bring it into a position where it could be viable. And also, by the way, back then, as I also recall, there was civil liberties institutionally wasn't necessarily always a unified effort in Ohio, because there was a state board of directors, the ACLU of Ohio. And as I mentioned before, much of the actual work that took place, unlike today, took place at the chapter level. Cleveland and Columbus and Cincinnati had major chapters, and Cleveland chapter was the most active chapter, but Cleveland chapter was also the chapter that had the most people who were contributing large amounts of money to the ACLU. And there were lots of times when there would be really significant, serious disputes, sometimes on business issues, but sometimes on litigation issues between the Cleveland board and the state board. And in fact, there were a couple of points where the relationships became so acrimonious that there were discussions about the Cleveland board ceding from the ACLU, becoming its own affiliate, and the like. And I mean, I remember there were times, as a matter of fact, I think was a member of one of the delegations of the state board that would go to Cleveland. We'd have mediation between the ACLU affiliate, the Ohio affiliate, and the Cleveland chapter, trying to work out a lot of these agreements. And eventually, they were worked out over a period of time, and eventually Cleveland became really assimilated into the state affiliate. But in any event, Benson was followed by the person whose name I'm embarrassed to say I can't remember. I can see her face, I just don't remember.
Is it Ann Zeller? Is that the next executive director?
Yeah, yeah, there you go. And she had Benson was a difficult act to follow. He went to practice law, and she had to put the organization on a sound financial footing. And she wasn't, I think she might have been there for 3 or 4 or 5 years. She wasn't there for a long period of time. And, that she turned the tide, and the organization became a more stable organization financially. And then Chris came on, and Chris has just turned the organization into sort of a marvelous business model for civil liberties, which has its pluses and it has its minuses. And I've discussed this with Chris many times. The pluses are that the ACLU has very significant resources now that allow us to do an awful lot of work, both legal program, public education program, legislative work, and the like, the kind of work that you're doing, which is great. But on the other hand, you go to board meetings and you sit there for 7 hours, and almost all of your time is spent running the business. So you're talking about this policy and that policy, and you're looking at balance sheets, and you're talking about, do we borrow money from here, and what about this investment strategy, and so forth. And so you end up, in a meeting that's 6 or 7 hours, you end up maybe with an hour and a half that really hasn't much to do with civil liberties. Most of it is running the business. Necessary. The organization is a much better organization, much more engaged, much more effective organization now than it was under Benson. But in some respects, it's much less interesting from a state board member's perspective, because you go to board meetings, and we used to come equipped with policy positions. We would write papers. We'd have these debates. We'd circulate drafts of papers in advance about, this group taking this issue on a First Amendment versus reproductive freedom issue, and so forth. And none of that, very little of that happens anymore. I guess it's the price you pay for success.
Well, you mentioned several of the executive directors. Are there any other board members, staff members, or volunteer attorneys with whom you worked over the years that you can remember?
Many. I remember a couple of the legal directors. Bruce Campbell was a wonderful friend of mine. Bruce now works for the Columbus Bar Association as an ethics counsel. Bruce was just a really good lawyer and a really wonderful person to work with. And I worked with him on a number of cases. Eleanor Alger was assistant legal director for a number of years, and Eleanor and I worked on a number of cases, and they were both effective, really good lawyers. A number of general counsels. David Goldberger, who was a professor at Ohio State University, is now retired at the law school, was general counsel for a number of years, and ended up arguing a case in the Supreme Court, and was famous for having been the lawyer from the Chicago ACLU who represented the American Nazi Party in the so-called Skokie case. I see his face. I had his name a second ago, and it's just escaping me. There was another guy who taught at Ohio State, Larry Herman, taught at Ohio State. He was general counsel for a number of years, a criminal law specialist, a really brilliant lawyer. And there's this other guy who I can see, can't remember. But so there were a lot of, both as general counsel and as legal directors, and just a lot of really good lawyers too. I mean, we had a lot of board members who were actively involved in taking cases. There was a time where we had sort of what we call a legal committee. Now, not so much, but back then we actually had a legal committee. There were a half dozen lawyers who would sort of perform an advisory role with the general counsel and in discussing issues or cases and talking about the position that the ACLU ought to take in a variety of cases. There are a number of lawyers who perform that role. My good friend Paul Moke, M-O-K-E. Paul was very active at the state board level for 25 years, including as president of the board for a period of time. But Paul and I became one of, or two of 4 or 5 lawyers who began to handle a lot of voting rights cases, beginning really with the presidential election of 2000. Paul's coming back on the board this fall. He'd been off as a result of mandatory term limits for a year. But Paul and I and Dan Tokaji, who is a law professor at Ohio State, who was on the board but is not on the board now, and a couple of lawyers from the ACLU Voting Rights Project in Atlanta were involved in 4 or 5 different voting rights cases, really interesting cases. I mean, I could talk a lot about individual cases as well, but some of the brightest, most interesting lawyers I've met have been ACLU lawyers that I've met through my work at the state board.
Well, you were just mentioning how you worked on several cases dealing with voting rights. So I'm interested, can you describe some of these cases in the context in which they took place and their significance?
Yeah, sort of. The first case, and in some respects the most significant case, was called Stewart against Blackwell. And that was a case that sort of came out of the 2000 presidential election, which, as you recall, was a very close election that was decided by the Supreme Court when Al Gore won the popular vote, but lost in the Electoral College to George W. Bush. One of the things that election brought to public light in a way that had not been done before was the extent to which the process of administering an election can be imperfect, and the numerous ways in which the administration of an election system can break down, causing really, really serious problems, really serious issues. One of those breakdowns took the form of the use of certain voting equipment. And Ohio is like, not all states, but it's like many states where there are 88 counties in Ohio, and much of the voting administration in Ohio is decentralized, so that the choice of what voting equipment to use, when a person goes to a poll ready to vote, presents him or herself, and wants to actually use an apparatus, back then there were 4, 5, or 6 different kinds of apparatuses that could be used. And back then, most of Ohio's counties used what was called a punch card machine, which was the same equipment that was used in Florida that created much of the controversy in Florida, the so-called hanging chads and danging chads and so forth, where you'd have people who would go into a voting booth, be given a card, put the card into a slot. There would be a series of metal arms that would have the ballot on parts of the ballot on each one of them. You would flip a card, you'd end up taking a stylus, and what you thought you were doing was poking a hole in a place in the machine, which would then perforate the card, and that would indicate your preference for whatever position on the ballot you were voting for, whether it was president or dog catcher. And the experience that in Florida showed that many of those ballots weren't counted, and many of those ballots, as a result of the machinery or the interaction between a voter and the machinery, many of those ballots resulted in a piece of paper that couldn't be read or that was confusing, and a lot of those ballots were thrown away. We saw that system that worked in Ohio, and we saw that there were some counties in Ohio that used various kinds of electronic equipment, which at least back then was thought to be much more reliable than the punch card system. And there were a couple of outlier counties that used what was called a lever machine, but by and large, the two most prominent kinds of equipment were punch card and electronic equipment. And we spent about a year and a half or so, maybe even more than that, after the election, doing research and conducting a study to determine around the state how the system actually worked. And we discovered that the much higher incidence of what's called residual ballots, or ballots that weren't counted, were ballots that came from the counties with the oldest punch card equipment. And so we ended up concluding that we had a system that was clearly unequal in its application, because people who, for example, who voted in Columbus, which had electronic equipment, would vote, and the chances that their vote would count were significantly higher, statistically significantly higher, than they would be in Montgomery County or Hamilton County, for example, or Summit County up in Akron that used the punch card equipment. So we ended up filing a lawsuit in federal court, and we filed it in Akron, challenging that system as in violation of the 14th Amendment to the United States Constitution, claiming that the state had a responsibility to provide either the worst equipment to everybody or the best equipment to everybody, but the state couldn't have a system where the odds that your vote would count would depend upon where you lived. And that case in pre-discovery stage and the litigation stage sort of lasted for 5 years. As I said, we litigated it, the team of 5 of us: Meredith Bell from Columbus, Philip and Laughlin McDonald from Columbus, the then legal director of the ACLU, whose name was Ray Vasavari, I forgot about Ray, and Paul and I were the 5 lawyers who handled that case. We lost the case if I had another hour and a half, I could tell you some interesting stories about how we lost the case and why we lost the case. We had a really interesting judge in Akron, but we lost the case in the district court, and we took the case up to the Sixth Circuit Court of Appeals. And the Sixth Circuit Court of Appeals, in an original decision, 2-1 vote, reversed the district court and essentially agreed with us that the system violated the Constitution. The state then did vote to procedure under federal practice rules, where it asked the Sixth Circuit as a whole court to set aside the decision of the original panel and to grant what's referred to as en banc review. ENBANC, en banc review, where all of I think that time there were the 9 or 10 judges on the Sixth Circuit would sit as one court, and then they would rehear the case. The effect of granting the en banc review was to vacate the decision of the original panel, so essentially the decision of the district court stood. One thing led to another, we had a round of briefings in the Sixth Circuit, and eventually the case became what was referred to as moot, largely because in the 2 or 3 years from the time that we brought the lawsuit until the last point of the case in the appellate process in the federal courts, Ohio had largely transitioned away from the punch card equipment, and so there were very few counties, if any, who were continuing to use it. So the basis for the lawsuit, arguing that this punch card equipment was not being used in a constitutional way, sort of evaporated. But that case took, thousands and thousands of attorneys' hours, and we worked on that case, as I said, for the better part of 5 years, I think. That was followed by working on a handful of other cases. There was a case out in Cleveland where Cleveland had been using had moved away from the punch card equipment, had adopted a form of electronic equipment, which is like lack of a better word, it's like a ATM machine where you vote, you're voting on a screen, and everything is done in an electronic way. And so Cleveland had adopted the electronic system, but the Cuyahoga County had decided that it wanted to move away from the electronic system and adopt what's referred to as an optical scan, what's called central count optical scan, which is another form of voting equipment, where the it's like a standardized test where the voter is given a card. The card is inserted into the voter then takes a pencil, for example, marks the places on the ballot that the voter wants to vote. The voter takes that card, then hands the card to an election worker, and either the card is actually inserted into what's basically a counting machine in the precinct itself, or the cards are collected and taken down to the central place in the county and counted overnight or the next 48 hours or so. In any event, Cuyahoga County decided, for a variety of reasons, many of which were financial, that it wanted to move to a central count optical scan. Well, we conducted some research, and also based on the research that we'd done in the Stewart against Blackwell, we thought it was pretty clear that the central count optical scan equipment really was a much less accurate system than the electronic system that they were already using, and that they were going to change. They needed to change to something that's called a precinct count optical scan system. So we told them what we thought they needed to do. They told us basically to jump in the lake, and we ended up filing a lawsuit up in Cleveland. That lawsuit we ended up losing because we asked a judge for a preliminary injunction. She refused to grant a preliminary injunction. And there were 2 or 3 other cases that we were involved in. We were involved in one case out of Columbus involving a dispute between the Republican Party and the Democratic Party, and that case went up to the Sixth Circuit and then up to the Supreme Court of the United States, and the ACLU was amicus. We were a friend of court in that case. We weren't directly involved. And there were 1 or 2 other cases that we were involved in. This was over a period of of 10 years.
Do you remember the names of the cases, the one in Cleveland and the one in Columbus?
The one in Cleveland was Project Vote versus Madison County, I think. I can get them for you. Project Vote against the Madison County. The one in Columbus, I think, was the Republican Party of Ohio versus White, but I'd have to double check that.
Okay, so you mentioned voting rights. Have there been any other hot topics that you've worked on while you're with the ACLU, and what has your view been on these topics?
Well, I don't approach civil liberties issues from the perspective of thinking about hot topics. I mean, things come up, they present civil liberties issues or they don't. It may be it is true, for example, in the case of voting rights. I mean, there was a period of time where we had a lot of voting rights issues, and we decided to place a lot of emphasis on voting rights issues. I mean, we had a group of lawyers in Ohio with a lot of support from Atlanta and then New York who were interested in voting rights issues. We had gained a lot of experience in voting rights issues, and so a couple of years ago, I think this was in the summer before the 2012 election, a bunch of us got together at the state office in Columbus and spent a day just brainstorming on a wide range of issues, trying to anticipate what issues might come up during the next election, and so we could be ready to sort of jump in and sort of triage lots of problems. Ohio's been a very fertile area for voting rights litigation. It's just had a lot of, that's not the only state, but it's had a lot of disputes with respect to the voting rights. And so we've studied things like the voter ID requirements and the effective voter ID requirements and change in registration requirements and so forth. So we sort of developed an emphasis and a kind of an expertise in that area. And so I guess for a period of time, it is fair to say that voting rights was kind of a hot issue for the ACLU because we just sort of adopted it. But I mean, much of the work that the ACLU has done since I began working with the ACLU, and it still does, a lot of it has to do with freedom of speech and freedom of religion. I've been involved in just a lot of free speech cases and either freedom of religion cases or what we call establishment cases, which is basically separation of church and state cases. We've been involved in reproductive freedom issues, not as heavily now as maybe we did 10 or 15 years ago, and that may be an area that we're going to be going back to with more emphasis in the next 3 or 4 or 5 years. A lot of issues involving equality. The voting rights cases that I talked about were also cases that involved questions of race because with respect to, for example, the use of punch card equipment, our research and we thought that our evidence established that the system not only worked to the disadvantage of people who lived in the counties that used the punch card equipment, but the system also disproportionately worked to the disadvantage of racial minorities. So we had a claim of violation of the Federal Voting Rights Act in that case. The ACLU has done a lot of prison work. And I've been involved, not more often than on the margins than directly, although I was involved directly in a case that came out of the Lucasville riots back in the early mid-90s. I handled a case in the Sixth Circuit involving the mother of a young man who was killed by correctional officers at Lucasville. But the ACLU of Ohio has done a lot of work, including after the Supreme Court, involving prisoners' rights litigation. Even now, most of the issues that we're getting involved in, that we're asked to get involved in now, have to do with free speech, freedom of association, and one of the religion clauses. That's pretty much where we spend much of our time.
You mentioned that case at Lucasville. Can you describe that?
Yeah, actually, it was an interesting case to be involved in. It also is a case that generated a course that I ended up teaching for years at the law school, for 7 or 8 years at the law school. Paul Mulkey and I co-taught a course that we called Civil Liberties Litigation. there was a woman by the name of Edna Haynes, Haynes, whose son Jimmy was in his mid-20s, and he was incarcerated at Lucasville, which is Southern Ohio Correctional Facility, which is the maximum security prison for Ohio. And I won't go into a lot of detail with respect to the facts, but on a particular day in December of, I want to say 1985 or 86, I don't remember exactly when, he was placed in the prison hospital, and one thing led to another, and the correctional officers tried to move him from a regular cell in the prison hospital to an isolation cell, referred to as a strip cell. And during the course of extricating him from the cell and moving him to this strip cell, he was severely beaten by up to 10 or 11 correctional officers who were involved in the move, and one thing led to another, and eventually the prison authorities called the Scioto County hospital. They sent an ambulance to pick him up, and he was dead on arrival when he got to Scioto County Hospital. And his mother, I didn't handle the case at the trial level. A lawyer who still is a very active lawyer, very distinguished lawyer in Ohio, by the name of Al Gerhardstein, was the principal lawyer in Cincinnati who represented Ms. Haynes. And he filed a civil rights lawsuit arguing that the treatment that Jimmy sustained and the resulting death violated his rights under the both due process clause of the 14th Amendment and the 8th Amendment, which is the cruel and unusual punishment provision of the federal United States Constitution. And the case was litigated at pre-trial stage in Columbus in front of a federal judge, and the ACLU, the plaintiff, Jimmy's mother, Edna, won one of the issues and lost another issue, and the case went up to the Sixth Circuit, and I was asked to handle the case in the Sixth Circuit, which I did with a colleague at the law school of mine. We handled the case in the Sixth Circuit, and we were successful in the Sixth Circuit in having the court determine that the various individual defendants, correctional officers and other prison employees, didn't have the benefit of what was referred to as qualified immunity under civil rights law, and as a result they were subject to damage judgments. And the case then went back down to the district court and eventually settled with a very significant monetary settlement. I didn't, once again, Mr. Gerhardstein then picked up the case. It was a case that was sort of co-counseled by Al Gerhardstein, who was not working as an ACLU attorney. He had a special arrangement, as I recall, with the ACLU. In most cases, when the ACLU asks local counsel to become involved in cases. By local counsel, I mean lawyers around the state who are not employed by the ACLU to get involved in cases. Lawyers agree to do that on essentially a pro bono basis, where the lawyers aren't paid for it. And if the case results in a court award of an attorney's fees, which will happen if it involves a constitutional issue and the plaintiff wins, the side that the ACLU represents wins, then the lawyer agrees that the money that's generated from the court award will go to the ACLU and the lawyer will not keep it. And that's a pretty consistent policy that the ACLU has had here and I think elsewhere around the country for a long time, but there are occasional exceptions that have been made. And as I recall, this is one of those exceptions where Mr. Gerhardstein handled the case, but he was handling the case as a private lawyer in cooperation with the ACLU, and Eleanor Alger, who was the ACLU assistant legal director at the time, was working on the case for the ACLU. Trying to figure out where I started this line of thinking from, but I was trying to explain that once the case was concluded in the Sixth Circuit and we were successful in getting the court to say that these defendants weren't immune, then the case went back down, and there was a lot of incentive at that point for the for the state, the Department of Corrections, and the Attorney General's office to settle the case, and they did settle the case.
So you also mentioned that you were involved in multiple cases dealing with First Amendment rights. Can you discuss one or two significant cases and the precedents that they set?
Well, discussing cases and talking about precedents are not necessarily the same issue. The ACLU, I think, considers it to be successful, and the civil liberties position that it maintains in a lawsuit to have prevailed, whether there's a judgment by the court or whether the case is settled or whether the other side agrees to stop doing what they were doing. If any of those things happen, if the case is settled or the other side agrees to stop doing what they're doing, those cases don't set any legal precedent, so they're not useful to another lawyer who comes along with a similar case. They can't use those cases. So, to a large extent, the ACLU is most successful when it doesn't establish precedent, because because it gets the other side to change its behavior, or to agree that it's been acting in a way that violates the civil liberties of whoever the parties are that the ACLU represents. I could go. It would be a diversion. I can talk about the Stewart against Blackwell case in that respect, but I won't. But there have been a lot of interesting cases. I represented the ACLU as a friend of court in a case involving a protest by Dayton police officers. The protest took place at a Dayton City Commission meeting. The Dayton City Commission was considering whether or not to adopt a policy where police officers would or could use what's referred to as hollow point bullets. And the commission decided against the use of hollow point bullets, and many of the police officers supported that policy. And so they had arranged for to appear at a commission meeting, a regular meeting of the Dayton Commission. And during the course of the commission meeting, there were some 100 police officers who got up at a prearranged time and walked silently to the front of the commission room. And most of them had in their hands 2 or 3 bullets, and they deposited the bullets on the desk of the clerk of courts, who was right in front of the dais on which the commissioners sat, and they silently did that, and they walked out of the commission room. Both the city political leadership and the police department didn't like that much. And so what they ended up doing was they tried to bring disciplinary action against the police officers who were involved in the demonstration. They charged some of the officers with wearing their uniforms without permission, because some, but not all, of the officers appeared at the demonstration wearing their police uniforms. And they charged other officers with conduct of becoming an officer, claiming that this was just inappropriate conduct that wasn't authorized by the police department and so forth. The Dayton Fraternal Order of Police was represented these officers, brought a lawsuit in federal court here, trying to get the court to enjoin or to prevent the police department from disciplining these officers on the grounds that the officers were engaged in free speech that was protected by the First Amendment to the Constitution. And this is one of those cases which sort of puts the lie to those critics of the ACLU who claim that we're always against law and order and that we're always representing the bad guys and so forth and so on. This is one of those cases where we asked to become involved in the case on the side of the police officers, because we as did they, believe that they violated their First Amendment rights to punish them for what we claimed was a protected speech. The federal district court issued an injunction in part and denied an injunction in part. The judge issued an injunction against the police department from proceeding against the officers for conduct unbecoming an officer, but did not issue an injunction, refused to issue an injunction with respect to the effort to discipline officers who wore their uniforms without permission. The case went up to the Sixth Circuit, and we had discussions with a lawyer for the Fraternal Order of Police who welcomed our involvement as amicus. We filed a request with the court to become involved as friend of court, and the court granted that. And the court granted us the authority to become involved as participating in amicus. Normally, when the ACLU becomes involved as a friend of court, that means just filing a brief usually. It doesn't mean actually appearing in the case or making an argument in court, but this is one of those cases where the Sixth Circuit granted the ACLU an opportunity to argue in the Sixth Circuit. And so I wrote a brief for the ACLU in that case, supporting the police officer's position, and argued the case in the Sixth Circuit, and the Sixth Circuit ended up ruling in favor of the police officers. I don't think that case set much of a humongous precedent, but on the other hand, if I were, and I have, representing people that were involved in a similar situation before, I would probably use this case as one of the many cases that I think would show that the courts have come down in favor of extending First Amendment protection to this kind of activity. There was another case that we were involved in as amicus, in which and this, again, is a case that sort of puts the lie, as I said before, to the sort of stereotype view of the ACLU as a bunch of left-wing socialist commies who were just trying to destroy civilized society as we know it. And believe me, there are plenty of people who take that position, and not all of them watch Fox News. Many of them do, but not all of them do. It was a case where a group of anti-abortion folks in Dayton wanted to, and did in fact, engage in protests outside a local family planning clinic that performed abortions. And the operators of the clinic went into court and asked the court to issue an injunction against the protesters to prevent them from protesting in the way that they were protesting at the time, which was on a public sidewalk, and they claimed that they were blocking access to the parking lot and a variety of other things. We were asked, actually I don't remember whether they were asked or whether we asked. Sometimes the parties involved in a case where we're not direct counsel ask the ACLU for support as a friend of court. Sometimes we see a case that we're interested in and we contact the lawyers and say we'd be interested in doing that. I don't remember which happened in this particular case. But we got involved in the case as friend of court, and actually I filed a brief for the ACLU in which we did sort of on the one hand, on the other hand sort of issue. Well, what our brief did, and what you don't expect the parties to do in a case like this, is we said that we have a case here involving sort of conflicting, equally valid and conflicting civil liberties issues. You have the reproductive freedom rights of people who want to go to the abortion clinic and who work in the clinic in order to conduct their business. You have the First Amendment rights of protesters, and the ACLU had been a strong supporter of both of those. And this is a sort of classic case where you have those rights coming into tension. And so what we ended up doing was I wrote a brief in which we sort of tried to balance both of those interests, and essentially argue that to the extent, or if the court is going to issue any kind of limitation on the protesters' ability to do what they were doing, that the court limit those rights to them as little as possible under the circumstances. And as I recall, the judge, in fact, issued an injunction, but the injunction was a very narrow injunction. At the end of the day, we weren't 100% satisfied with, but I think really went a long way towards respecting both the rights of the people who operated the clinic and the protesters to engage in their work. I'm thinking back, as I said, I've been doing this for a long time, so having cases pop up. I remember a case that we were involved in came out of the Dayton area, in which it's very similar to a case that the ACLU is now involved in. in which a woman who worked for a school that was operated by a church, by a religious organization, became pregnant. And she wasn't married, and as a result, given the doctrine of the church and the policies of the church, they fired her, and she filed a claim with the Equal Employment Opportunity Commission, or it might have been the House Civil Rights Commission, I don't remember which, claiming that her dismissal violated her rights under the employment discrimination laws. And that's one of those cases, one of the reasons the case sticks out so much is because it's one of those cases that, once again, raises conflicting civil liberties issues. You have the religious freedom claims of a religious institution to operate it to a large extent immune from intrusive government regulation, and to make decisions about who works for them and under what circumstances and under what conditions. And on the other hand, you have the equality claims and the reproductive freedom claims of an employee who wants to argue that it may be that the church-run, religious-run organization is immune from some kinds of government regulations when they're acting in a theological sense, but not when they're acting in a general sense, like when they run a school that's open to everybody. And I remember we had, that's one of those cases where we had position papers that we produced for the board, and we had probably 2.5 hours of argument one afternoon in Columbus or Cleveland, I don't remember where it was, about what position the ACLU ought to take in that issue. In that case, and we ended up, as I recall, as friend of court in that case, including filing an amicus brief in the United States Supreme Court. And the United States Supreme Court ultimately decided that case. It's very much like, it's very much like a case we have now on a woman, I think, in Springfield who worked for a church-related organization who became pregnant and so forth. I mean, as I said, there's just lots of cases, and they kind of tend to blend together after a number of years. But those are a couple of cases that come to mind.
Well, in that last case, did you agree with ACLU's position to file the amicus brief on her behalf?
I'm sure I did. But I think at the time, I think that the position that I took, and actually I wrote a policy paper. It wasn't a dissertation, but it was probably a 10 or 12-page paper. And at the time, I think I took a position, and I've had a tendency over the years, not for all of my professional life, but at least for the last half of my professional life, when it comes to looking at claims of religious people and religious organizations and balancing those claims against other civil liberties issues, when the rights of religious people and religious institutions tend to conflict with other rights like equality rights or reproductive freedom rights or other First Amendment rights. Over the years, I've tended to be, I think, more sensitive to the religion-based side of the equation than a lot of my colleagues and friends have been on the ACLU. And so as I recall, I think I probably took a position in this case that was much more supportive of the school's position, of the religious institution's position. Although I certainly recognize the reproductive freedom and equality-based claims of the employee, I think the position that I took was tried to indicate that there was more to the argument on the part of the religious institution than some of my colleagues believed. And I'm trying to think of actually what position we ended up. I'm sure what we ended up doing, which is one of the most valuable roles the ACLU plays as a friend of court, that any true amicus probably is not just the ACLU. When you're not representing directly a party, you're free to sort of take the blinders off and to sort of recognize maybe there's a range of positions involved in the case and try to bring to the court's attention that range of issues in a way that's not just narrowly focused on the particular specific rights of your client. And so I'm sure that what we did in that brief, you saw my office, and I'm sure I have a copy of it lying up there someplace or another. I've looked at it for a long time, but I'm sure that we ended up sort of trying to bring the court's attention to both of those issues. Where we ultimately came down, because eventually you have to come, we don't have to, but usually you come down in support of one position or another. I actually don't remember where we came out on that question. I just remember it was a lot of fun. It was really interesting. And it was an important case.
Well, another case you were involved in was Secora v. Fox. Can you describe this case and how it relates to ACLU's current role in stopping discrimination based on sexual orientation?
Yeah, sort of. Claude Secora, Montgomery County, which is where Dayton is, has I think the second largest Air Force base in the country, which is Wright-Patterson Air Force Base, and there are 60,000 people who work at that base. So it generates $2.5 or $3 billion of local economy. Mr. Secora was a lifelong, career Air Force guy. He was a sergeant, and he had just finished his sort of penultimate tour of duty when, if he signed up for another, as I recall, it was a 4-year term, then he would be eligible for retirement. He had an exemplary service record. Great ratings by all of his superior officers. Nicest guy you'd ever want to meet. He re-upped, and shortly after the time that he re-upped, it came to the attention of his superiors. Somebody had contacted his superiors and had made allegations with respect to inappropriate sexual conduct that they claimed that Mr. Secora had engaged in, and the sexual conduct in question was homosexual conduct. As things went at the time, this was way before Don't Ask, Don't Tell. This was the time when, you know, anybody got a whiff that you were gay in the service, you were out on your ear. At the time, his commanding officer conducted an investigation. They impaneled a board. They sent him to psychiatrists, and they eventually discharged him involuntarily from the Air Force, solely because of his sexual, what they claimed to be his sexual status. Although he never admitted to being homosexual, but they claimed that since they had credible evidence that he had engaged in a homosexual act, that he was therefore by definition homosexual, and he could not continue in the military. He came and I'm sure the case got to me from the state office. He came and talked to me about it, and one thing led to another, and we decided that we would challenge this discharge. And so I filed a lawsuit in federal district court in Dayton, seeking an injunction against the military from. By the way, in addition to discharging him, they also issued a demand against him that he return to them with interest the re-enlistment bonus that he got. Okay. So this was in the early '80s, I think, early to mid '80s. This was a time when courts were just beginning. The advocacy on behalf of gay rights was really beginning to grab hold and gain traction. Lawsuits were just beginning at the point where litigation was being brought, beginning of the case of growing awareness in the legal community about the constitutional issues and so forth associated with discrimination against gays and lesbians and others. And so there really wasn't very much precedent. There were no good Supreme Court cases, and very few cases litigated this question. So once again, I brought a lawsuit against the military, asking them to issue a correction of military records. He wasn't really interested at this point in getting back into the service. What he wanted was an honorable discharge, and he wanted to be able to retain his reenlistment bonus. Well, unfortunately, what happened with this case is it hit a black hole in federal court here. There was a lot of initial skirmishing I was involved in this case for almost 10 years. There was a lot of initial skirmishing that had to do with what lawyers refer to as administrative law issues. And the government, the Air Force's position was that before this matter could go to court, it had to go to a specialized military agency called the Board of, I think it was called the Board of Correction of Military Records. And this agency had the sort of initial authority to look into this matter and make a decision as to whether to change his discharge from dishonorable discharge to an honorable discharge. Dayton has had a wonderful federal judge for many years. He's brilliant. He's just a wonderful person. He's got a great judicial temperament. He's very open to civil liberties issues. I don't think he's biased in favor or against civil liberties issues, but he's very open to civil liberties issues. He has always been sort of a really good judge for the ACLU to get in a civil liberties case. But for many years there was one downside with getting him, and that is he also had a reputation which even he would concede was well deserved for many years of never deciding the case. And so once you got the case in his court, you had no assurance that case would be resolved in the near future. And that's what happened with this case. The military moved on procedural grounds to delay, either dismiss or delay the case. I don't remember. That the appropriate place to resolve the matter was in the Bureau of Correction of Military Records. So we ended up taking the case to the Bureau of Correction of Military Records. That took about 2.5 years before we got any response or resolution from the Bureau of Correction of Military Records. I'm trying to remember. Once again, a long time ago. I'm trying to remember what I know the case didn't go to judgment, and I think that what happened was that somewhere along the line, something happened to Mr. Secora, his circumstances and so forth, where he decided that it was no longer. He was no longer interested in pursuing litigation, because I think eventually, after 7 or 8 or 9 years before we actually got a judgment from the court, we ended up dismissing the suit. So once again, that's a representation that didn't involve any precedent. But it was one of the first. It might have been the first. I don't remember, but certainly one of the first cases involving gay rights that the ACLU Ohio got involved in. But over the years, I spent many hours on that case.
So you alluded to this earlier, but what kind of reputation did the ACLU of Ohio have when you first became associated with the organization, and how has it changed over time? Reputation
in whose eyes? I can't speak for the general public. I mean, I think that it's not just the ACLU of Ohio, it's the ACLU. I mean, I think the ACLU, when I talk to audiences about the ACLU, or friends or colleagues about the ACLU who don't know much about it, I often refer to the ACLU as really one of the most misunderstood organizations of its kind in the country. Many people, in my experience, who regard themselves, in organizations that regard themselves as politically conservative, have this sort of knee-jerk response that, as I said before, that the ACLU is some lefty communist organization that's interested in anarchy and chaos and representing criminals and poor people and illegal immigrants and all the bad folks in society don't deserve representation. That's a caricature, but a lot of people, in fact, I think would buy that completely. And one of the things I try to persuade my conservative friends and colleagues, of whom I don't have a lot, is that the ACLU is a quintessential is that the ACLU is a quintessentially conservative organization. The civil liberties position is a quintessentially conservative position. The ACLU argues in many, many areas of life, government has no business sticking its nose into your life and telling you what to do. Now that's the sort of thing that the Tea Party could run on, you know, that except they don't recognize government. But I mean, we recognize, I think we tend to recognize that government sometimes has legitimate objectives that need to be taken into account with respect to regulation. But you know, oftentimes the ACLU becomes involved in cases where the ACLU ends up taking or aligning itself with what will be the conservative side. I refer to the police officer case and the abortion protesters case and the like. And there are plenty of cases where we're on the same side as right to life organizations and other organizations. There are you know, plenty of cases where we support the claims of religious institutions to be free from government regulation. And a lot of people will think that the ACLU is a godless, literally godless organization, you know, stocked with people who are atheists and don't believe in God. Some of the most religiously committed people I know are civil libertarians and ACLU people. So I think that what's happened is that through much of the work that we've done, especially in Ohio, I think that you know, we've established a public record that caricature of the ACLU is just a caricature. It's not at all accurate. You know, that we are able to go in front of all kinds of groups and individuals, Republican, Democrat, conservative, liberal, progressive, whatever you want to call them, and argue, you know, that an organization like ours is committed to enforce and respect people's rights against government, constitutional rights. I think that given the public education program that the ACLU has engaged in, very active over the last 5 or 8 years, much more active than when I first got involved in the organization, given the really effective legislative program that we have in Columbus, with Gary and others, you know, I think the legislature, even in Ohio, which is a very conservative, very heavily Republican legislature, there are a lot of people in the legislature that respect the ACLU. I know I'm involved now in a statewide commission, a member of a statewide commission, where I have a chance to talk with legislators on a pretty frequent basis. And you know, when they hear that I'm involved with the ACLU, I don't really get, you know, sneers and nasty looks the way that I might have gotten them 10 or 15 or 20 years ago. So I think that I think that there's a different. I think if you conducted a public opinion poll, the public opinion polls today wouldn't be a whole lot different than they were 15 or 20 years ago. And that's because there's so much propaganda from the interests that usually oppose us. That's become effective. There are so many talking heads on talk radio and so many media sources, including cable television and cable news and all the rest of it, that have this continual barrage of just, you know, just disinformation about lots of things, including the ACLU, that it's very difficult to fight that. So I think if you did opinion polls, they probably wouldn't show that that the ACLU has a positive reputation on behalf of the vast majorities of the people of Ohio. But I think that the ACLU has a different image in many circles that matter, including the legislature and including courts, than might have been the case 15 or 20 years ago. And of course, at the Supreme Court level, the ACLU is one of the, if not the most active litigator before the Supreme Court. When the ACLU files a brief, lawyers read it, judges read it, and judges, you know, tend to respect the ACLU's voice in these in issues that it cares about. But as to, you know, what the average person on the street thinks about the ACLU, I'm guessing that the average person on the street either hasn't heard about the ACLU, or if they've heard about it, they've listened to Rush Limbaugh or, you know, or Fox News or something like that, and they don't have a very good opinion at all. It's very, very difficult to combat that. All you can do is continue to do the work that you're doing and do it well, and, you know.
So overall, have the courts and the practice of constitutional law changed in the past 3 decades? Are there significant events that you can reference that have changed people's views of civil liberties?
Well, in the courts, yes, because our constitutional law has become a much different face today than it had 25 or 30 years ago. And largely that's been because of the Supreme Court, which since the mid-1970s has been a court that almost consistently has had a conservative majority. A majority of conservative judges appointed by Republican presidents who have tended to take a very narrow, restrictive view of individual rights, tended to take in many cases a broader view of the role of government, be much more deferential, except in selected areas, and become much more deferential to government. And so as a result, the legal environment, the legal jurisprudential landscape today is much different than it was when I started. Then you had the Warren Court, you had the beginning of a really robust view of free speech rights. You had the beginning of a very significant body of law on church-state that prevented the government from supporting or becoming involved, in any active way in religious activities. You had the Roe against Wade and the sort of the beginning of recognition of reproductive rights for women, and so forth. And so at that time, you looked at the courts with a lot of promise and a lot of optimism. And in fact, there was good work that was done from the civil liberties point of view in the courts. There still is good work that's done, but it's much more difficult to get that work done in the courts now because of the body of restrictive constitutional law developed by the U.S. Supreme Court. And as a result, much of the favorable work that gets done for the ACLU tends to get done not at the Supreme Court level, where you're establishing good precedents for civil liberties that will affect everybody in the country, but rather at the district court level, at the trial court level. Oftentimes you hope that, as a matter of fact, we frequently discuss cases and we look at the prospect of the possibility that the case will be appealed and the likelihood of the possibility that the Supreme Court will take the case. And oftentimes our prediction that the Supreme Court will take a case is sometimes a reason for us not to get involved in the case. So that now we much more rely upon small victories. I would call them small victories that take place at the trial court level. In the federal system now, most of the courts of appeals are also very conservative. The Sixth Circuit Court of Appeals, which is where we are, tends to be a very conservative court, and so you don't expect to get a lot of good civil liberties law made in the federal courts now. One difference today over when I started 25 or 30 or 40 years ago is a lot more work is taking place in the state courts, civil liberties work, not just in Ohio but around the country than used to be the case. It used to be the opposite. It used to be a civil liberties sort of presumption that when you had a good First Amendment case, a reproductive freedom case, or a voting rights case, if you could get the case in federal court, you take the case to federal court. You would do what you could to stay out of state court. That's less true now, in part because the federal courts have become more conservative, and also in part because some state courts have begun to take more responsibility for civil liberties and civil rights, not just under the federal constitution, but under their state constitutions too. States can interpret their state constitutions more broadly than the U.S. Supreme Court interprets the federal constitution. So I think that there's more of a serious inclination to think about state courts as a place to raise civil liberties issues. Not a dramatic shift, but a measurable shift. The other thing is that work in the legislature is much more important than it was, 25 or 30 years ago. At a time when at the legislature, started running roughshod over civil rights and civil liberties, you thought you had a reasonable prospect of making good law in the courts and going up to the Supreme Court. You were less concerned about being effective in the legislature. Now, it's much more important to become effective in the legislature because to the extent that you can limit the damage that legislatures do to civil liberties, you don't have to worry about taking cases into court. So, and I think that's consistent with the ACLU Ohio's significant emphasis over the last 7 or 8 or 9 or 10 years in working in the legislature. I think we've become a really important part of our program, and it's been a very effective part of our program doing that work in the legislature. I just lost sight of your question.
That's okay. So what has been the biggest accomplishment that you achieved while you were while working at the ACLU of Ohio? That's a difficult question. I don't really look at this as work that's done because there's an accomplishment associated with it. I do the work because I think it's really important work, and I do the work because it's really interesting work. I mean, I've gotten a whole lot more out of working with the ACLU than I've given to the ACLU. Both in terms of, one of the things that's really been interesting and important for me as a law professor, as a person who's spent, the ACLU is my avocation. My vocation as a professor of law is that I've been able to use my work with the ACLU as a way to both generate legal scholarship about civil liberties issue, and I've written a lot of law review articles that have been generated out of cases that I've worked on for the ACLU, and I've also been able to incorporate a lot of the civil liberties work that I've done into my classroom, into my courses. As I said, I built 2 courses. Paul and I have built a course in what we call complex civil litigation, which has been a voting rights course, and the other course was civil liberties litigation. Both courses were developed on cases that I worked on for the ACLU. So I've developed 2 courses that are part of this curriculum at our law school that I never would have even thought about developing had I not worked with the ACLU. I've also been able to, I think, get some students involved with the ACLU, some of whom have gone on to actually handle cases for the ACLU. I think that my work with the ACLU as a practicing lawyer has, to some extent, I would be very careful about overemphasizing this because I don't think it can be easily overemphasized, but I think has given me some degree of credibility as not just as a sort of an egghead, head in the sky law professor, but as a person who is a practicing lawyer, as a person who has been involved in interesting cases and so forth. So, I think if there's an accomplishment, it's in being able to contribute to legal scholarship as a result of the work that I've done, being able to positively affect the lives of clients, being able to, I remember all of the years that I spent when we had this active chapter, and all those years, there were 6 or 7 or 8 years, I don't remember exactly how many, when as I said, I would have students who staffed these phones, and sometimes they couldn't have students, and so I was getting direct phone calls. My office number was listed in the phone book as the ACLU for some time, for the ACLU phone number. And in the vast majority, there were thousands of those phone calls I got over 7 or 8 years. Maybe not thousands, but certainly up in the high hundreds, if not thousands. And in the vast majority of those cases, for a variety of reasons, they were not cases where the ACLU could get involved, either because there weren't legal rights, or because there might have been legal rights, but they weren't civil liberties issues, or because the ACLU simply couldn't take that kind of case because of limited resources and so forth. But I always found that spending sometimes 2 hours, half an hour, 20, 25 minutes on the phone with somebody who came to the ACLU probably never having heard of it before, or having heard of it, didn't hear good things about the ACLU, kind things about the ACLU, came to the ACLU, talked with a lawyer, had somebody maybe for the first time listen to what their problem was. And even if they were told that we couldn't help them, at least provided an ear to somebody who maybe was at their wit's end to try to figure out what to do about a problem. And sometimes I could make suggestions. Sometimes I could refer them to a private lawyer. Sometimes I could find ways to direct these folks.
And, you know, if I was successful as a member of the ACLU, it's because maybe I had a positive effect on some of those people's lives and helped some of those people, even though they never turned out to be fancy court cases. So.